Good afternoon and welcome to the Insurance and Pharmaceuticals Subcommittee of the Health and Government Operations Committee. We have two bills to discuss today. So if you are here expecting to discuss or see a discussion on House Bill 565, sorry, but that will need to be rescheduled. There is some work being done with some state agencies on that bill. So we have to hold it for another day or so to make sure that we can try to address the issues that were raised in our marathon session yesterday. And again, I want to thank the committee for your persistence in trying to work through that bill yesterday. It was a great discussion. So we're going to start with House Bill 919, and that, and Lisa, I'm going to ask you to talk about the bill and the proposed amendments to it.
So House Bill 919 is an emergency bill that requires the insurance commissioner to enforce a provision of law requiring of clean claims by an administrative service organization responsible for managing care and paying claims for specialty mental health services for Medicaid enrollees. There are amendments on page 9 of your packet. The first amendment is technical, and the second amendment applies to the administrative service organization, statutory provisions that require the payment of interest on clean claims that are not paid in a timely manner, and establish penalties for violations of the clean claim payment law. The amendment also establishes that the Maryland Insurance Administration may investigate or examine the administrative services organization for potential violations of the clean claim payment law under certain statutory provisions authorizing market conduct examinations.
Okay, thank you. And Delegate Bagnall, would you like to speak to the bill?
Sorry, I'm on two bill hearings at the same time.
Sorry.
So the bill is it did pass second reader in the Senate. We did amend it to make an emergency bill.
Okay, hold on a minute, Delegate. If you've got it on YouTube, can you mute YouTube because we're hearing the delay?
Can I come back and speak in just one moment?
Sure. Who else, if you want to speak on this bill briefly, if you feel compelled to speak on this bill briefly, raise your hand in the participants panel. Delegate Krebs. Unmute.
Sorry, I had lost my screen. The one question I have, I unfortunately don't have the packet with the amendments, but can you tell me a request by some of our providers to extend the time frame for reconciling the estimated payments, because they've not been, a lot of these providers have not been able to reconcile these payments. Is there anything in there about that in the amendments?
Lisa, I'm going to look to you because you know them better than I do.
And Madam Chair, I can help too, if you'd like.
Lori, go ahead.
Thank you so much. This bill does not address the reconciliation, the recoupment of the estimated payments and reconciliation process, because this just addresses what already exists in statute in the insurance article around prompt pay and allows the MIA to have oversight of that provision. But we do have budget language in, just so you know, around the reconciliation process, holding Optum accountable to certain standards that they have to meet before they can start taking money back.
So Lori, are you confident that we're going to have an opportunity for our providers to have this extended reconciliation? If you're confident that that's being fixed in another place, I'm fine with that. But right now, moving forward, that's great in this bill, but we've got a huge problem between last year and now, just reconciling what the payments have been. So if you're confident that that's taken care of, I'll be okay with it.
Delegate, I'm not confident about the reconciliation process at all, but I think that this bill is addressing a separate issue, which is moving forward around the prompt payments, which is also an ongoing problem. So this addresses one problem. Hopefully the budget language will address another, but we'd like to keep you informed as we go forward because this has been a real problem for us, as you know.
But we'd like to stay informed because some of our providers are going to be out of business if we don't get this straightened out. So it's very important.
Thank you. And And Madam Chair, I might just say, I was listening to Delegate Bagnell. This bill has passed third reader in the Senate. It's being re-referred to you. It passed unanimously out of committee and on the Senate floor as well.
Okay, thank you. Steve Weiner, are you wanting to speak to 919?
I'm sorry, I didn't realize what bill we were on, but
Okay.
if you guys would be kind enough to let Brian Hose in the chat for the next one, that's
Okay.
why my hand's raised. Thank you.
Okay.
Bye-bye.
Thank you, Steve.
But can I ask a quick question? I think
Absolutely.
Delegate Bagnell said, so is there supposed to be another amendment that makes it an emergency? Because I don't think that's included here. And
Lisa, it was always an emergency bill.
oh, okay, then I don't.
It's
Then we
not-
don't
it's
need
not
to do
an
it.
amendment. It
Okay.
was put in that way.
Okay.
So I don't know, Delegate Bagnell, if you can come back now, or if not, so just to remind the subcommittee, this bill is addressing the issues with the payer not reimbursing our providers in a timely, our mental health providers in a timely way. Apparently some
Rural areas.
serious,
also
serious technical issues. Like Bagnell, did you want to say anything else?
Yes, I apologize. I just want to make sure I was muting the right committee. So yes, I apologize. It did pass third reader in the Senate. Well, I have worked very closely with Senator Augustine to make sure that we kept our bills in alignment. So the bill as amended that you see before you is the same bill that passed the Senate. There was also an article in Maryland Matters this past week by the CEO of Optum that basically said nothing was wrong, everything was great, and gave no indication of any sense of urgency, which made us feel all the more reason that we needed to move forward. We also requested a letter from MIA, which you should have, saying that if the bill, passed as amended, they would be able to to operate immediately.
Okay. Thank you, Delegate. Commissioner, would you like to speak to this at all?
No, I think that the delegate has said everything that makes sense, just to assure everyone that the day that this law becomes law, if it becomes law, we will be ready to enforce it.
Great, thank you. Do I have a motion on the amendments?
Move the amendments.
I've got them. Do I have a second?
Second.
Okay. Okay. Discussion on the amendments. Delegate Krebs, your hand is up.
Yes, I just wanted to mention to the insurance commissioner, and I don't want to editorialize here, but this year we were told to bring bills down that were very important, and this bill is very important. I mean, it really is something that we need to do before we get out of here, and I hope the insurance administration takes it seriously, because this is a real problem that we need to solve this year. And I'm glad that our committee has gotten this through and the Senate is on the same page. So I just wanted you to know how I don't care what the guy from Optum said, we have a huge problem that needs to be resolved. And if they can't understand that it's a problem, we have a problem right there. So I obviously support the bill and the amendments.
Delegate Krebs, I can assure you that I have already met with my team. And if this bill becomes law, the very day that is effective, the next day there will be an exam letter that goes out.
Okay. Any other discussion on the amendment? All right. Here, seeing no hands, those in favor of the amendment, please say aye. Opposed, please raise your hand in the panel, in the participant panel. Seeing no opposition, the amendment passes unanimously. Can I have a motion on the bill as amended?
Let's move the bill.
A second? Any further discussion on this bill? Okay, those in favor of the bill as amended, please say aye. Those opposed,
Aye.
please raise your hands. Delegate in the panel. Seeing none, the bill passes unanimously. Thank you very much. I understand
you.
that Mr. Johansson is in the waiting room. Can we let him in? Let's see if there's anybody else. Yeah. or affectionately known as waiting room purgatory. So 601, this is my plan for today on 601. We will not be voting on this bill today. We will have to,
No, I need to talk to somebody.
committee has to meet
There's
again.
gotta be
As
a
I said,
human
we're
right to
trying to
talk
work
to.
out some language on 565. So given that, we need to meet. Today, what I would like to do is there are a set of amendments coming from various sources on 601. And you will recall that 601 is defining purchaser in our statute in such a way that would apply all of the laws that we have in the statutes regarding the pharmacy benefit managers to the pharmacy benefit managers who work with ERISA plans, which are those that are who have federal oversight. And this is the result of the Supreme Court case in December that said there is some purview of the state under those conditions. And it was defined in the Rutledge decision. So given that, I believe everyone got a copy of Delegate Kipke's reprint. Is that right, Lisa?
It's written in your name, delegate.
In the packet, there's an additional change that I think someone from Epic will verbally speak to, but
Okay.
that there is a reprint, starts on page 2 of the packet.
Okay.
Changes from last week on page 5 of the packet in the definition of purchaser. We've removed the language individuals who reside in or are employed in the state, and the definitions reworked a little bit to reflect that. Starting on page 6 of the reprint, there are several sections of the insurance, or several different sections of the insurance article that are brought into the bill. And this was discussed by MIA last week. They suggested that there be some tweaks to current statute to comply with Rutledge. So those are brought in 15-1606, 15-1628, A2, and 15-1628.3. And then there are also some changes in there. MIA had discussed wanting to have a little bit more time to review contracts. So in 15-1628, which is the bottom of page 6, top of page 7 of the reprint, there's language that would give the insurance commissioner 60 days, up from 30 days to review. And it's the language has changed a little bit to reflect forms, which is, I guess, what MIA is usually what they review are forms, not the contracts. So there's language to reflect that. And then it would also give the commissioner the option of extending the initial review period for an additional 30 days if they provide written notice to the pharmacy benefit manager. This would also then change when the contract could become effective if the commissioner does opt to extend the review period. And that's, you can see that on the reprint on page 7.
Okay. I guess what I'd first like is for MIA to respond in terms of what these changes would mean in your work. The changes that are in this reprint on the handwritten pages 2 through 6 or 2 through 7.
2 through
So
7.
I'll defer to David and to Van in terms of, most of the substantive comments from a procedural standpoint with the filings. We would like perhaps consideration of removing the form filing requirement completely. If it is important, and I can understand why it could be important to maintain that repository up front, as opposed to in the event of a complaint. Another approach might be to have informational filings. So there's no approval, but the MIA has that information. They can act on it but they don't have quite the same time constraints. And while this is very helpful and we thank you for this consideration, another approach could be that we don't actually make approvals, but we get it for informational purposes, which allows us to do market conduct type things, but isn't quite the administrative or regulatory burden. But on the, and David will approach that as well, but Van and David will speak to the other amendments.
Before you speak to that, I think, Madam Chair, that's where we were going with that, that they would have to file it. So if there's a complaint, you already have it in hand and you don't have to wait to receive it, but not necessarily review and approve. We did that for historical reasons, I think. I don't know if there's any benefit doing it any longer. Somebody could let us know if there is, but I think that that's probably unnecessary at this point.
So if I'm understanding Delegate Kipke, what you're suggesting is that we remove the review and approval process across the board, but that they would have to file their contracts. Is that, you're on mute.
I don't know if there's a value to it anymore. If somebody believes that there is, then, certainly let us know.
Okay.
The whole idea was to get those contracts in hand so that the MIA could take a look at to get a better understanding of the market. But certainly, if there is value to it, we could amend it out so that the ERISA plans they would just have to file them.
Okay. I have a couple of hands, but I wanted to go to Van or Dave Cooney to speak to this, which situation would work better for you? And answer, and if you have an answer for Delegate Kipke's question about the value of reviewing the contracts. I think, David, it's you.
Sure. Thank you, Delegate. So based on what's in the reprint, the extension of time periods, as the Commissioner mentioned, we really appreciate that, and that would be very helpful. That would definitely alleviate some of our original concerns as to where we would have to focus our resources when these contracts came in. But as far as the idea of whether there's a value in reviewing these contracts up front at all, there may be minimal value for the ones that actually impact carriers, because there are some additional requirements that we do look for in those contracts to the ones we are currently getting. But particularly with expanding this to be self-funded plans where there would be really hardly any statutory requirements that we would actually be looking at. I don't really see a lot of value to getting these up front, as long as, again, we can have them when we're reviewing a complaint and we can see the actual, contracts then. So again, as it's proposed in the reprint, that will help us with our resource issues, but there's not necessarily a whole lot of value in getting these up front regardless.
Okay, great. Van, yeah.
Yeah, I would also add, with regard to Delegate Kipke's idea of essentially having a file and use with regard to the contracts, that would enable us to have the contracts on hand, and in the event we needed them for a quick review for a complaint or for a market conduct thing. It also would enable us to have them should there be a PIA request for them. But with regard to enforcement, because we have the authority to investigate already under market conduct or through complaints, the value of reviewing the contracts beforehand, frankly, is diminished. So I think that is, obviously that was the suggestion of the Commissioner, and I think it's a very good one.
Okay, great, thank you. So I'm going to go to Brian Hose.
Thank you. Thank you, Delegate Wilson. I think for us, the benefit of having these reviewed and having a timetable is that we no longer get faxes in the middle of the night that take effect the next day for amendments to these contracts. So if we could somehow preserve that, I understand that, they're reviewing these, and if there was a problem, they could certainly go back and look at them. But just having that timeline also stalls this amendment takes effect tomorrow. That we were seeing a good bit of and we're not seeing now. So that would certainly help us and would mean a great deal, even though it may not mean a great deal to the MIA.
Okay. Kim Robinson?
Thank you, Madam Chair. I certainly understand Mr. Rose's comment. I think those are probably two separate provisions, the time for when something takes effect versus the MIA's review. So I think that there's probably room to discuss being able to do what he just asked. My question was actually, I wonder if I could ask a question to David or to Van. My
Yes.
experience has been that on a market conduct or a complaint, it's not really the template that you ultimately need, it's the actual contract. Because one of the things is going to be, is the contract line up with the template, and what are the specifics? Because of course, when it's template, there are going to be provisions that are going to be filled in that may be at issue in the complaint. So, I mean, I think to both of your point that there's only but so much utility in even an informational filing from a market conduct or complaint standpoint. Are you relying only on what's filed, or are you still asking then for the contract that's been actually executed in the instance of a market conduct or a complaint?
David, I think I'll take this one. Kimberly, I think the answer is that in any investigation, and this is true now with regard, even when there's a contract review, you're going to want to see the actual contract, because you're going to want to make sure that that the contract that they have is actually consistent with what has been filed with us. That's part of it. And then also to make sure it meets all the requirements of the statute. So we would want to have that for sure. But that's regardless of whether or not the contract is submitted to us or not.
Right. And the reason why I asked was because I think, to Mr. Cooney's point about sort of what the utility of the upfront review or even an informational filing, I think that you do get plenty of access when you're actually looking at them, and we do end up having to refile something with you and actually are filing something more specific and different when it actually matters, as opposed to the informational filing. So I just wanted to be clear that it doesn't sort of alleviate your ongoing need to still make the request.
Yeah, I just want to add one thing. I mean, to both your points, I mean, that is true, because the contracts we currently get filed in advance now, a lot of the information that is filed is variable as it's permitted to be. So we do not see the specific reimbursement that's going to be negotiated with particular pharmacists up front. We can only see that once we're actually looking at the executed contract after the fact.
And you would be looking at the executed contract when there's a complaint?
Yes, and when this bill passed a couple of years ago, it required us to adopt regulations, and we adopted regulations establishing a complaint process, and it specifically requires the pharmacist to include a copy of the executed contract when they file a complaint with us, and the PBM to provide one to us anytime we request it.
Okay. Steve Weiner?
Yeah, I think David just answered that. I mean, our concern is just if there is an issue, a complaint, can you get, with these amendments proposed, will you still be able to get the information? Historically, a pharmacy would make an appeal and the response would be, you're getting paid what you're paid per contract, and that was it. There was no, so as long as you can still get that for a complaint and these amendments don't change that, whatever can be done to streamline you guys is great.
And these amendments would apply to plans, PBMs that work with ERISA plans, right? The same, so that same ability to look at the contract, if these amendments were to pass, that same ability to look at contracts when there's a complaint would exist.
And we might have to look at that for some technical revisions to make sure, but that was our understanding what the intent would be. And so
Okay.
it's that way.
Okay, so that's why we are giving people time to look at this revisions. I have Mike Johansson.
Yep, thank Madam Chair. And I guess I know that there's the packet amendment. There was the more subsequent amendment that I think Lisa just sent out. But the change to 60 days, and I understand that in the amendment I'm looking at in the packet, it now limits it kind of more clearly to the way the regulations are worded, which is the form of the contract changes. But it still has the review language, correct? So to some extent, we're extending the period for review, which makes a longer period of time before we can even use the new form. So do we really need more time if we're taking out the review and it is more of a file and use, which I thought I heard from MIA?
Yeah, and I think that's where we're going. That's what this discussion is leading us to take
That
that.
wasn't something that was taken into consideration in the amendment.
Right.
That was just something that was
Yeah.
brought up orally.
This is a new discussion based on these amendments. So
Thank you.
trying to respond to them. Kim, is your hand still up or just didn't take it down? Okay, cool. Is there anyone else who wants to speak to these amendments in the reprint? I don't see any hands. So let me ask.
Yes.
Okay, I see
Sorry.
Michael's hand again, but David can?
Yes. Just wanted to address a slight change that APEC requests on the last page of the reprint concerning section 1628.3. The amended text as sent around in the packet would remove the words or a purchaser from both of the subsections A and B of that text. This provision, which was added to law last year, is very important with regards to generic effective rate requirements that the PBMs have been placing on pharmacies directly or through their PSAO. And so we suggest adding the language that the PBM may not do either of the things that are specified in this provision on its own behalf or on behalf of any purchaser, just to make sure that that they don't try to implement GER programs through a purchaser indirectly.
Lisa, I'm gonna look to you to say, do we need to be that explicit here? Or if we say just a pharmacy benefit manager may not, is that clear enough? Or do we need to be specifically either independently or on behalf of someone else?
MIA might, I'm not sure if they would have an opinion on this. I mean, that,
I'm gonna look to Van on this one.
sorry.
I understand he's the MIA's.
So as I'm reading the statute now, it says a pharmacy benefit manager, and I'm going to take out the word or purchaser. A pharmacy benefit manager may not directly or indirectly charge a contracted pharmacy. So I think the or indirectly would prohibit them from doing that. So on the other hand, I'm not sure that the amendment would alter that in any way. So
it doesn't hurt.
Correct.
Okay. So if it doesn't hurt it, let's put it there. So it'll be a pharmacy benefit, something like a pharmacy benefit manager may not do any of these things on its own or on behalf of a purchaser. Okay. Okay. Other questions on the reprint? David? Ken?
I'm sorry, I don't have any other comments on the
okay.
on the reprint.
Michael Johansson?
Thank you, Madam Chair. So this reprint is a kind of revised version of Delegate Kipke's, prior approach. We do still object to the scope of the definition of purchaser and the application of it without more clarification to certain provisions of the PBM law. The way this in the reprint in the packet, the definition of purchaser applies to not just formerly ERISA exempt plans. It applies to all plans in the state of Maryland, including local governments, whether they're counties and cities and perhaps others. And we heard from MIA during our work group that if that is the intention of the committee, this would be the very first time that any aspect of a county health plan for its employees with respect to any of its benefits, the health plan benefits, the vision benefits, the dental benefits, or the pharmacy benefits would be subject to MIA regulation. So we think that's definitely much broader than the bill is introduced, which was simply to capture ERISA exempt plans, as Rutledge decided. So we certainly have an objection there. And secondly, we really do believe the analysis that would be required of the subtitle for all the PBM provisions and making a determination of which are permissible under Rutledge to be applied to ERISA exempt plans is still a work in progress. And Madam Chair, you asked us for some information.
Right.
If I could, can I have Heather from PCMA give you a quick update on where we are with that response?
Sure.
Where we're headed. Thank you.
Thank you. Thank you, Madam Chair. Just quickly, I know that there was discussion in the last subcommittee working group about a more in-depth analysis on the Rutledge decision as it pertains to the subtitle we're discussing here, the full PBMs section of the law. We have requested outside legal counsel to do a high-level memo, which will sort of provide some examples of what parts of the PBM statute could be impacted by Rutledge and which parts definitely don't fall into the same category as the initial Arkansas law that was, being decided in Rutledge, and anticipate that sort of high-level memo will be made available momentarily in the next few hours today.
Oh, okay.
And then a more substantive sort of section by section analysis with sort of legal backup on why, various provisions wouldn't be impacted or shouldn't be impacted would take us a little bit more time because that's more of a legal research project, but happy to engage in doing that and provide that to you in the committee so that we can all have a fuller discussion about kind of the case law and what leads us to come to some of these conclusions with the backup associated for it.
Great, thank you. Delegate Kipke.
Thank you, Madam Chairman. I just wanted to respond to Mr. Johansson, who, as you know, I'm very fond of. The definition issue is really my fault, and it's because I have this rigid way of thinking about ERISA and self-pay. I always get them put together in my head because we have to follow some of the same rules as we legislate for both of them. But it was always my intent to include anybody that we could possibly include in this bill. And the objections to including, self-pay, I think would only be valid if it had something to do with benefit plan design. And since we're not saying what benefits have to be included, and we're just talking about the underlying regulation of reimbursement and the way that they operate, and it's not about core plan design, I don't think that we're out, stepping into an area that would be inappropriate. So with that, just one final thing, clearly, I think that this should apply to everything except for plan design based on the Supreme Court ruling. However, I think that for me, at least, it's really essential that we move forward with something meaningful, which is why, under protest, the chairman has beat me into submission and, to at least move forward with the reimbursement aspects, the unfair and bad acting that took place in GER and MAC, and that's why we had to pass those bills. I'm glad we can move forward with that. I'm hopeful that we'll have the votes to do that. But also, I think it's important for the MIA to report back to us so that we could take further actions potentially next year. So, while I'm not exactly happy about not moving forward with the full package, I do appreciate that there's some compromise here on all parts to move forward with something meaningful. Thank you.
Thank you, Delegate. And so before I call on anyone else, let me just say, while I was twisting an arm. I did so on behalf of the fact that conversations that we've had, there's been a lot of discussion over the full scope of the impact of Rutledge. And even among the people that I'm looking at on the screen, there's a lot of disagreement around what this really means. I feel fairly confident in the fact that when probably we are called into court on a decision we might make with respect to Rutledge, we'll be able to defend the reimbursement piece pretty easily, because that's what the Arkansas law was about. The other pieces, I suspect there are going to be tens at least of suits across the country with respect to Rutledge. And what I would ask is that MIA be watching those, what's happening with those over the year, because I think that will inform us, Delegate Kipke, in terms of, what the possibilities are for moving forward. So I appreciate Delegate Kipke's openness to that discussion and willingness to narrow this to a place where we could feel comfortable in being able to defend our decision. Saying that though, Heather, I would like the information, because I think it's going to contribute, to the thinking as we go forward. And, both the information that you can give us in a few hours and also, if you have the ability and opportunity to do the deeper dive over the interim, that would be really helpful as well. So Michael Patty.
Yeah, thank you, Delegate. Just looking at the amendment language specifically in regards to this report, I don't want to get too far ahead, but I noticed that it had a December 1st, 2021 deadline. Unless the commissioner disagrees, we typically operate with a December 31st deadline for legislative reports. Just gives us a little bit more time based on, internal processes.
We could probably do, right, Delegate Kipke? Could you give him another 30 days?
As long as Michael promises for no extension requests. Those are pretty common, you know what I mean?
But not from MIA. I have always got
that's
MIA
true.
on time.
Yeah, I'm just teasing. Yep, thank
you. So Van?
Yeah, I'm sorry. With regard to the alternative amendment that you have suggested that Delegate Kipke mentioned, I did want to raise a technical point, and that is what you've done is created an alternative or another definition of purchaser within the same subtitle, and so that will only be applicable to certain sections, and there's that could lead to some confusion, because the word purchaser is also used in the definition of pharmacy benefit management services in 15-1601. And so to the extent that that phrase then is in those other sections, you'll have essentially competing definitions of purchaser in the same section.
Could I just quickly, the chairman, I don't know if she had the draft in front of her. What the requested language is, after directly or indirectly, comma, on its own behalf or on behalf of any of its customers or clients.
Okay, I didn't have that.
She said purchaser, and it says they objected at the time. I thought it would be all right, but the language is on behalf of any of its customers or clients.
So also it will mean that, this is up to you all, but it would mean that a pharmacy benefit manager that only services ERISA plans would not be subject to the registration requirements, because it wouldn't fall because the definition of purchaser in the other section is still excluding ERISA, but the MAC pricing, it would only be subject to the MAC pricing provisions. I'm not sure that's what you're intending.
I don't.
The language is from David Kahn, who's the outside counsel for Epic. I don't know if you can take a look at this, David.
I think you guys are talking about two different things. I think Van is talking about the alternative amendment that wasn't in the packet, and Delegate Kipke, you're talking about
I see.
your second amendment, I think.
That's correct. That's what I'm talking about. Yes.
Okay.
If I've moved ahead too far, I'll stand down.
Okay. I mean, are you seeing a conflict that we need to address as we consider this evening?
I guess if I can jump in here, I
Okay.
agree. It sounded like Van was talking about the amendment, the alternative amendment that has Delegate Colson's name at the top of it, and would limit the change in the definition of purchaser strictly to 1628.1 and 1628.2.
That's right.
And then Delegate Kipke is talking about a slight revision I made to his proposed new bill text. It strictly having to do with 16.28 or 1628.3. Okay.
1528.3.
I'm sorry, 1628.3, the GER provision. That's what I
Right.
talked about earlier. So yes, so we're talking about two different things.
Yep.
The only comment that I have with regard to the alternative amendment that Van was discussing is that I think that the definition of purchaser also should be broadened for 1628.3. Okay. Or alternatively, 1628.3 could be changed in the way suggested by the Kipke redraft, as we talked about earlier, so that it broadly encompasses all of PBM's functions, doing reconciliation on behalf of itself or on behalf of any of its customers or clients. So if that could be added to the alternative amendment that has Delegate Collison's name on it, then I think that's important to preserve the integrity of 1628.3.
I'm going to have to take a deeper look at that because my inclination is to not broaden this beyond the two sections that directly affect the calculation of reimbursement rates.
Well, but
So,
with respect, 1628.3 is integral in terms of the reimbursement because GER and effective rate reconciliation has been used to change reimbursement after the
Right.
fact. And
Right.
so unless that is included in the discussion, then the change is incomplete.
all right, okay. We'll look at that before we come back tomorrow. I'm not sure when the committee will meet again, sometime this week, perhaps tomorrow. So just so we're clear, because as I said earlier, I do have a hard stop. Where we are going now is making the changes that are in current law with respect to rate reimbursement for now only for the individual and small group markets to ERISA plans and state and local plans is I think what the delegate was just saying, but without the contract review, but contract submission, but not review. And so that, and then the enforcement process would be complaint-based. So if a pharmacist made a complaint, then MIA would request the entire contract in order to resolve the complaint. Have I captured that correctly, Lisa?
I'm going to have to go back and redraft and talk to a couple of people to figure out exactly what is going, because I was a little bit confused about what parts from where are going to. Yeah.
We'll be working on this, and we may be calling on some of you in order to do this. So I'm going to call on Delegate Krebs and then Michael Johansson, and then we're going to need to end the meeting. So Delegate Krebs.
And I'll be quick. I just wanted to go back to Michael Patty about the report due. And I appreciate that you like to have the timelines the same, but if possible, I mean, we need to get the report back. We gotta read it to prepare for next session. So even if we change the date, my request to you is to expedite this and try to get it done so we have time to look at it before, before we get down here next year, because it's really, we've been waiting for this for a long time. So
Oh, absolutely.
if that's possible to expedite it, we would appreciate it.
Okay.
Thank you.
And thank you, Delegate. And Michael Johansson.
And finally, Madam Chair, just to kind of keep under consideration the effective date and the applicability language, if there is a county plan that has authorized the use of generic effective rate and that it becomes prohibited, it will change their perhaps cost or reimbursement in mid-year, which can affect not only the county government, but the employees that obviously contribute to those costs. And we certainly don't think you ought to expand it to those groups, but if you do, I think it's another reason that the effective date needs to be part of your conversation.
And to clarify, contracts are typically redone at the beginning of the year, in a calendar year, or is it a fiscal year, or?
I think the county things are all over the place, right? I mean,
Okay.
it could be July 1, they could be January 1, March 1. I thought years ago was the state plan
Yeah.
March 1. I can't remember, right?
Okay, all right, we'll have to take that in. Thank you. We'll take that into consideration. Thank you all. That concludes our work for today. Please watch the website to see when we will be meeting again. When we meet again, we'll be taking up this bill 601 and House Bill 565, which is the medical debt protection bill. Thank you all again, and have a great afternoon.
Thank you.
Thank you.